Right. I suppose we'll get going then. For those of you who haven't previously met me or dealt with me, I'm Rory Goodson. I'm one of the junior business and property practitioners at King's Chambers. And this is part of our King's Chambers Young Professionals webinar series. I'm going to deal with two interconnected points today in relation to the practice direction on business and property witness statements. The first of these is one that was specifically requested, I believe, by a solicitor who had attended a previous session, being the applicability or otherwise of that practice direction to witness statements in specialist business and property proceedings in the county court rather than in the High Court. And then I'm also going to touch on the question of sanctions for non-compliance under that practice direction briefly as well at the end. While we're going on, if you've got any questions, put them in the chat. What I will try and do is deal with them at the end if we have time, and if not, then I'll try and, when these slides go out, maybe add an additional one at the end that just deals with a couple of points if they've come up. So do feel free to do that. I'm sure that many of you are familiar with the practice direction at issue here. It's 57AC, trial witness statements in the business and property courts. It sets out a large number of procedural steps required in the creation and the formulation of witness statements. The intention behind the practice direction is to produce better witness evidence. We could debate at length whether it has had that impact, I'm sure some people having some quite strong views upon it. Thankfully, that's not within the scope of what I intend to discuss today. It also requires a statement of compliance to be added at the end from practitioners. The substantive elements of the statement are important and are quite significant. It is not just as one solicitor said to me, who shall remain nameless, said to me when I reminded them that the practice direction applied, oh yes, that means I have to add that little bit on at the end. There is something rather more to it than that, as it instructs the entire process of crafting the statement in the first place. But in terms of their use, it's stated to be for use at trials, as well as two other specified proceedings, being unfair prejudice petitions and winding up petitions by a contributory on the just and equitable ground. What's noticeable about the practice direction itself is that it makes no mention whatsoever of the county court, only refers to it as applying to the business and property courts. So what are the business and property courts? The phrase is very commonly used. It's often used inaccurately, I think. The business and property courts themselves are defined within practice direction 57A.1. I've set that out there. Paragraph 2A dealing with those courts which are set in London, 2B those in the district registries of the High Court, which are located further afield. It's notable again within those paragraphs that there is still no mention of either the county court or the specialist division of the county court or the specialist work of the county court as being included within the umbrella of the business and property courts. The regional centres are referred to as being the district registries of the High Court. These are further defined in an additional practice direction. I apologise for the wide range of practice direction terminology, but if one is to get into this, unfortunately, there is quite a lot of that at play here. This is 57AA. Paragraphs 1.1 and 1.2 define those district registries as being the business and property court district registries in Birmingham, Bristol, Leeds, Liverpool, Manchester, Newcastle and Cardiff. It also sets out the question of business and property work and the county court judges. What it states at paragraph 4.4 is that those business and property court work county court judges must spend 20% of their time on business and property work. What it also says in that practice direction is that this has to be in either the business and property courts or in the county court. Now, it seems fairly clear to me from that fairly brief analysis of the wording of the various practice directions at play here, when you consider it, that the county court is considered to be supplemental to the business and property courts rather than included within them. If you look, therefore, at the practice direction in and of itself, you would say that on its face, 57AC should not apply to business and property work within the county courts. However, as many of you will be aware, and as I'm sure will give rise to the queries that have prompted this talk, there are a wide variety of approaches taken by a wide variety of judges across a wide variety of courts as to how this can be applied. Speaking from personal experience, I've had cases where there was no reference at all made to the practice direction, and where one side has complied with the practice direction in producing witness statements, the other side has not complied with the practice direction in producing witness statements. This became an issue at a pre-trial review, and the judge in that instance stated that while he thought the practice direction probably did apply, he wasn't going to make an issue of it and impose any sanction. The practical impact of that is therefore not significant, but when we get round to dealing with sanctions and the possibility of sanctions, it can of course be more significant than was at play there. I'm sure many of you will have encountered a wide variety of approaches yourselves. On the one side, you have places like Leeds and Central London, county courts, and also I believe Liverpool as well, who will increasingly include a requirement within directions issued for multi-track business and property work, requiring that those witness statements comply with the practice direction itself. There is, of course, a benefit to that for practitioners because it makes the position clear. Obviously, you therefore have to incur the additional time in producing compliance statements, but the position is clear and there's no excuse or reason for confusion in those circumstances. The power of the court to impose the practice direction where it would not otherwise apply is of course within their jurisdiction to do so. Manchester, in my experience, doesn't do this, and I'm sure there are other examples out there of courts that have a similar approach. That does lead to the kind of confusion that I raised previously, where you arrive at trial or you arrive towards trial with a witness statement which hasn't been produced in compliance with the practice direction, or one side has and one side hasn't. And an argument then arises as to the applicability of the practice direction to those proceedings. As I've said previously, looking at the wording of the various practice directions, I think it's pretty clear that it shouldn't apply. However, judges seem to like the practice direction. They like the way that it frames the evidence. They like the way that, I think as they see it, it can reduce the material before the court and speed up the process. And I think that plays into some of the approaches that we see in court of judges being inclined to favour the practice direction in circumstances where on its face it probably, in my view, as I say, shouldn't or doesn't apply. There's an additional point here that I would just briefly raise as I note there on the slide. Practice Direction 57AD, the much discussed disclosure practice direction, explicitly excludes their applicability to specialist business and property work in the county courts. And there's possibly an interesting point here were this ever to be argued, or were one to have to deal with it by way of application or in court, as to whether there's an inference within that without an express statement that it doesn't apply, Practice Direction 57AD would have applied. And what is the implication of that for Practice Direction 57AC that doesn't include that exclusion? Personally, I don't think there's anything to that, and it probably wouldn't go very far. But it is an interesting question as to why the drafters of that practice direction felt the need to explicitly exclude the county courts and the business and property work within the county courts, and the drafters of 57AC did not. I suspect that the point that is most at the forefront of people's minds is, well, what should we do about this? So if we're dealing with a case, particularly with one that has directions that don't make any reference to the practice direction, but are marked as business and property work within the county court, what is the approach to take to this? There is no authority on the point. There is no guidance, so far as I've been able to locate, on the point. As I say, I think it's pretty clear, and one can make a very compelling argument that it shouldn't apply within such proceedings. And on that basis, you will be able to proceed as before the practice direction, or as in other county court work not marked for the attention of business and property judges. However, as I say, there is an inherent risk to that. Judges are inclined to favour the practice direction, from my experience. And you are potentially leaving yourself open to sanction from a judge who considers the practice direction to apply. There are two possible practical approaches that can be taken in response to this, as I see it. The first of which may be less optimal, is to simply treat the practice direction as applying. I appreciate that there are additional requirements in the compilation of evidence involved within that practice direction, but it does often produce better evidence, in my view, and there is a benefit in the conduct of litigation to that practice direction being followed in any event. If it is treated as applying, of course, you completely close off any possibility of being deemed liable for sanction under the practice direction at a later stage. The alternative, and perhaps the better approach and the most sensible approach, is simply to seek to have it explicitly dealt with. As we've seen, there are courts, numerous courts, that deal with the question explicitly within their directions. As I say, Leeds, Central London, and I believe Liverpool as well, from directions that I was dealing with there fairly recently. Of course, raising this point to the CMC or within the question of directions could run the risk of a requirement being included that would not otherwise have arisen. But I would contend, before we go on to look at the question of sanctions, that there's probably a risk worth taking, where the alternative is running the risk of large swathes of the statement being struck out or required to be redrafted, looking to get a firm tell on whether the practice direction will be considered to apply to those proceedings. Because, as I say, I think it ought to be treated as a proceedings by proceedings approach rather than an overarching rule. In looking to do that within the discussion of agreement or argument over directions would seem to be the most sensible approach for practitioners to be taking, and the best way of closing off any risk of the imposition of sanction later on within the court proceedings. As I say, the absence of authority on guidance on the point isn't helpful. It necessarily causes confusion, and there is confusion out there within this area of the law and relating to the practice direction. It's not possible, therefore, to give a firm answer on the question. But what I can say is, from looking through the practice direction that we have this morning, it seems pretty clear to me that it shouldn't apply. The difficulty is that some judges appear to consider that it does, possibly, as I say, because they just like it. And I think that requires a practical response from practitioners to try and work out the best way through that state of affairs. One could very simply turn up and argue the point. And I think, as I say, you'd have a very strong case to do so and argue that there shouldn't be any sanction because it doesn't apply. There is, of course, an inherent risk to that. And when balancing everything, it may be worth seeking to avoid that possibility arising. The second point I wanted to deal with this morning, and it is tied into that first issue, is the question of sanctions for non-compliance with the practice direction. These are specified, or the power for this is specified at paragraph 5 of the practice direction. And there is within that an extremely wide discretion as to the kind of sanctions that the court can impose. These go from striking out the whole of the statement, some of the statement, or requiring the redrafting of sections of the statement. And these are all within the court's discretion to do so. What is worth highlighting, however, is that there's not mandatory. There's nothing automatic about a sanction for non-compliance. It has to be either on the application by the other party or on the court's own motion, where it considers it appropriate to take some sanction under the practice direction. We do have some case law now on the question of how the courts have approached this. I've set all that out there, or some of that out there on that slide, in particular a couple of cases that I think are particularly useful in this regard. As an overarching view and looking at it more generally, I would say that the courts appear to be reticent to impose serious sanction for non-compliance. In particular, the sanction of strikeout of an entire statement appears to be something that they're rather unwilling to do. And we can see that from these two cases in particular. The Mansion House case was a case in which the court determined that they would address the specific instances of non-compliance within a witness statement, rather than striking out the whole of the witness statement as they were invited to do by the opposing party. And they stated that the court shouldn't strike out the entirety of a statement unless it was reasonably necessary to do so. What amounts to reasonably necessary is, of course, vague, but this was assisted in the subsequent Blue Manchester Limited decision. Whereas in that case, I believe it was His Honour Justice Stephen Davies, sitting as a High Court judging the TCC, noted that he allowed the statement to remain, despite there being some breaches of the practice direction, on the basis of what he considered to be a useful core of compliance information. And the breaches within that statement were what he considered to be not particularly egregious. Those two cases, I think, both show that the courts, while they are keen for parties to comply with the practice direction, are more inclined to tailor any sanction to the specific instance of non-compliance, rather than simply to take a more hard-nosed approach and say, if you've not complied, you need to go off and do the whole thing again. They're more inclined to get out the TIPEX and remove paragraphs or even sentences that they consider not to comply, rather than striking out the entire thing. The latter case is also interesting for a comment made by the judge in his decision that parties should be proactive in pointing out where they consider another party's statement not to be compliant. And this should be done in correspondence upon receipt of statements, and should probably invite agreement for amendments to allow the statement to comply with the practice direction. He warned against and stressed that the courts would not take kindly to what was considered to be opportunism or unnecessary trench warfare in creating satellite litigation, arguing about the compliance or otherwise with the practice direction. That was really stressed against, and comes through in his decision in relation to the statement as a whole. I think in that case, particularly his decision to retain a statement which he said had the useful core of compliant information. So I think those two cases are useful in that regard. And the final point I wanted to discuss was something else that's come up and I've seen raised or queried before, which is the relevance of the Denton position to sanction under 57AC, the question of relief from sanctions under 3.9, This was fairly recently addressed in the Prime London Holdings case that I've noted there on that slide. This was a case in which a claimant had made an application to strike out the entirety of the defendant's witness statement. And in response, the defendant had made an application for relief from sanctions. It wasn't 100% clear what the sanction that they were seeking relief from was. And the judge in his judgment held that presumably the application for relief was targeted at the sanctions sought by the claimant, i.e. the strikeout of the entire statement. And in circumstances where the judge, instead of doing so, struck out 11 paragraphs on one sentence of the judgment, but left the remainder of the statement to stand on the basis that the rest of it was compliant. The judge therefore held that the sanction against which that application had been targeted had fallen away in any case, and so wasn't relevant. What I think is more interesting, particularly on this decision, is when he deals with the question of Denton in paragraph 44. He says that he went through the three criteria very briefly and noted that he didn't believe that they would entitle the defendant to any relief. However, what he considered was that where a judge has been through the process of questioning whether it is appropriate to impose a sanction under the discretionary power of 57AC, he considered it would then be perverse to proceed to grant relief under Denton and under 3.9. And I think that must be right. In a situation where there's no automatic sanction, there's no sanction being imposed, the idea that a court would be required to consider discretionarily whether they will impose sanction and then immediately consider whether relief should be given from that sanction is a sort of circular exercise. Insofar as Denton was worthwhile, it appeared to be something he'd taken into consideration when considering whether to impose the sanction in the first place. And I would suggest that probably that is the extent of the value of Denton in such situations following this judgment, although there's not been any other consideration that I could find within the authorities of the point. Just therefore to circle back on the points I've dealt with through that, in relation to the applicability in the county court, on the face of the practice direction, as I say, it doesn't apply to the county courts and not to the business and property work within the county courts. And in the absence of some express amendment of the practice direction or some express guidance, I wouldn't consider that to be the case. However, there is confusion because various courts take various different approaches in relation to it. My practical advice, as I say, is either to seek clarification in directions or at the CCMC as to the applicability, or alternatively just to comply out of caution. There are benefits and drawbacks to that approach, but it may be something that is worthwhile. And finally, in relation to sanctions, the discretion here is very wide. The courts have been reticent to impose a strikeout, particularly of entire statements. And finally, that last point I raised, insofar as Denton is relevant, it may only be relevant in assessing whether the sanction's relevant and appropriate to be applied at all in the first place. I thank everyone for attending this morning. I hope that's been of some assistance. I appreciate that dealing with a wide variety of practice directions and the minutiae of those may not be the most stimulating of topics. We've got a few minutes left. I can see there are a couple of questions in there. The first question, does it apply in insolvency proceedings? Insofar as it does, it's set out within those statements at the unfair prejudice petitions, and also within the specific kind of winding up petition that is there. Other than that, it doesn't, as far as I'm aware. A couple of other questions. Do you think that one should make or insert an allowance or provision in the drafting of cost budgets for the possibility of applications to court for potential non-compliance with PD 57 AD as a practical consideration? Is that meant to say AD or AC? AD is the disclosure question. AC, thank you. When it comes to drafting of cost budgets, making provision, I think there are better ways of dealing with it than that. I think the more sensible approach would be to seek to either agree it in directions or seek to deal with it when directions are being laid down. I know there's a comment there from someone who's saying that may be too late to leave it to the CCMC, and the witness statement work may already have been begun by then, and whether it could be agreed with the other side. Of course, it could be agreed with the other side that there was an intention not to comply, but a judge could still impose the requirement. You could agree directions which state that the practice direction doesn't apply, and put those to the court following agreement between the parties. But a judge could still refuse that and seek to impose the practice direction if that is their preference. So I completely appreciate the point on that. The risk is that the judge simply doesn't go along with the agreement between the parties, as they wouldn't be bound to do. So as I say, I understand why one might want to take that position, but I think there's a risk to that as well. Someone else has put in only multi-track, not fast track or intermediate. It will apply to, well, the question in the county courts would only apply in relation to what is marked as business and property work. I've not encountered a fast track trial that has been marked as business and property work, but if that were the case, then yes, the same questions would arise here. Would you advise that we budget based on PD 57 AC statements then, even without approval or determination by the court? If you're dealing in the court centres that, by way of habit, impose or put in a direction requiring that they be compliant with 57 ADC, then that's certainly something you can do very easily. In terms of budgeting outside of that, as I say, it's extremely difficult to work out what the courts will do in certain instances where directions remain silent. The budgeting question is something that a couple of you have raised now, and it may well be that, in fact, assuming compliance and complying with them when the budgeting question and the early preparation of witness statements arises may simply be the more sensible approach to take to avoid anything arising later on. A further person has questioned, can both parties be sanctioned for non-compliance even in a county court depending on the judge's preference? In theory, yes. In theory, if both parties are non-compliant, the judge could strike out sections of both parties' witness statements if they considered it to apply. I suspect it would be a brave judge in front of counsel on both sides arguing for non-application of the practice direction to nonetheless overrule them both and apply it and seek to strike out the statements, particularly where the parties have proceeded on the basis that it doesn't apply. I think that would be brave, but it's not necessarily impossible. If both parties haven't complied and the practice direction is seen as applying, then theoretically, yes. I've got a question there. Is it applicable to Inheritance Act claims? I don't specifically know the answer to that question. So I'm not going to pose a guess on that. Insofar as it falls within the scope set out earlier, then it would. But I'm not going to deal with that specifically. I'm conscious now that we've just run over the time frame. I'm happy to answer any further questions if they are. I don't know how they can be sent in by the means by which you will receive this email, this link perhaps, and I can add those into a PowerPoint that when these slides go out in due course. But I as I say, I thank you all for attending this morning. I hope that's been of some help. I appreciate that the position is not overly clear, and so in some sense, my answers won't have been completely clear. But beyond that, yes, thank you very much.